Alright, Chapter 29, Remedies and Infringement of Patent and Other Actions. 281, Remedy Infringement, Patent Presumption Valid, Defense Injunction Damages, Attorney Fees, Time Limitation on Damages, Limitation on Damages other than Markings and Notice, Action, Infringement of Patent containing invalid claim, Pre-American Inventors Act, Action for infringement, patent containing invalid claim, additional remedy, infringement, design, patent notice, patent suits, derived patents, Pre-American Invention Act, interfering patents, false marking, non-resident patent services, notice, voluntary arbitration, presumption, products made in patent process. Liability of states, instrumentality of state officials, infringement of patents, improper deceptive inception, promotion, advice of counsel, joinder of parties. Title 35 U.S. Standard Code 281 Remedy Infringement Patent shall remedy the civil action infringement of patents. Title 35 U.S. Standard Code 282 Presumption of validity of defense. Generally, a patent shall be presumed valid. Each claim of the patent, whether the independent, dependent, multiple dependent form, should presume valid, independent validity of the other claims. Dependent or multiple dependent claims shall be presumed valid, even though the dependent upon invalid claim, the burden in establishing validity of a patent, any claim thereof, shall rest on the party asserting such invalidity. Defense of following shall be defenses any of the actions or actions involving validity, infringement of patent shall be pleaded. Non-infringement, absence of liability, infringement, unenforceability, invalidity of patent and claims and suits, grounds, specified Part 2 as condition, patentability, invalidity of patent or any claim and suit of the failure to comply, any requirement, Section 112, except for the failure to disclose the best mode, shall not basis of any claim patent may be cancelled here and held invalid, otherwise unenforceable, or any requirement, Section 251, any other fact or act made a defense by this title, notice of the actions, and during extension patent term, in the action involving validity, infringement of the patent asserting invalidity infringement shall be given the notice in the pleadings, otherwise writing in a diverse party, at least 30 days before trial, and country, date, name, number, date, and name of the patent, any of the patent title, date, and page numbers of any publication to be relied on, anticipation of the patent suit of the exemptions or exemptions exemption in action in the United States federal court claims showing the state of art and the name of the address of any person who relied upon the prior inventor or having the prior knowledge of having previously been used of the offered sale of invention patent suits in the absence. Such notice of proof said matters may not be made at trial except for such terms the court requires. Invalidity extension of the patent term portion, Section 154B or 156 because of the material failure. One application for extension to the direct by the director. To comply with the requirements of section shall be the defense and action involving the infringement of the patent during the period of the extension term and shall be pleaded with the due diligence termination, Section 156D2, when not subject to review in such action. Title 335 U.S. Standard Code 283 Injunction. Several courts of the jurisdiction of the cases under the title may grant injunctions according to the principle equity to prevent violations of rights acquired by patents on such terms as the court deems reasonable. Title 35 U.S. Standard Code 284. Upon finding the claim, court should award the claimant damages adequate compensate for the infringement in no event less then reasonably royalty for use made of the invention infringer together with the interest and costs fixed to the court. When the damages are not found by a jury, the court shall assess them. In either event, the court may increase the damages up to 3 times the amount found and assess. Increased damages under the paragraph shall not apply to provisions under Section 154D. The court may reserve expert testimony as an aid to the determination of the damages and what royalty would be reasonable under the circumstances. Title 35 U.S. Standard Code 285 Attorney Fees. The court exemption cases may be awarded reasonable attorney fees to the prevailing party. Title 35 U.S. Standard Code 286 time limitation on damage except otherwise provided with the law. No recovery shall have any of the infringement committed within 6 years prior to the filing complaint, counterclaim, infringement in the action. In this claim to the United States government for the U.S. patent invention of the period before bringing suit up at the 6 year but the date of the receipt with a written claim with a compensation from the department agency with the government having authority to sell such claim at the date of the mailing by the government notice of the claimant with the claim has denied but shall not be counted as part of the period referred to in the preceding paragraph. Title 35 U.S. Standard Code 287 Limitation of Damages and Other Remedies. Patenting persons making, offering, sale, selling with the United States patented article for under them or importing patented article into the United States may give the notice to the public that the same is patent either by fixing thereon the word patent or abbreviation PAT dot, together with the number of the patent by fixing thereon the word patent abbreviation PAT, together with the address of the posting on the internet and accessible to the public without charge for accessing the address and associated patent article, the number of the patent, or when the character of the article. This cannot be done by fixing it or to the package wherein one or more of them is contained. The label containing like notice in the event failure so to mark the damages recovered by the patent in any action for infringement, except for the proof of the infringer was notified of the infringement, continued for the infringement thereafter, in which the event even damages may be recovered only for the infringement occurring after such notice. Filing an action infringement shall constitute such notice. B1. Any infringer under Section 271G is subject to all the provisions of the title relating to the damages and injunction except as the extent of the remedies modified with the subsection Section 9006 of Process Patent Amendments Act 1988 and modification remedies provided subsection shall not be available to any person who the practices the patent process. B. Own controls of the own control by the person who practices the patent process. C. Has knowledge of the infringement of the patent process used for the product importation, use, offer, sale, and sales constitute infringement. 2. No remedies for infringement under Section 271G shall be available with respect to the product over the possession of the transmit. The person subject to liability under section of the person had notice infringement with respect to the product. The person subject to liability shall bear the burden of proving any such possession or transit. 3. In making determination with respect to the remedy action before brought by infringement, Section 271G, the court shall, in 1, good faith demonstrate with the defendant with respect to the question of disclosure. 2. Good faith demonstrate with the plaintiff with respect to the disclosure. 3. Need to restore the exclusive rights secured by the patent. For B. For the purposes of paragraph 8 of the following evidence, good faith. 1. Request disclosure by the defendant. 2. Response with a reasonable time by the person receiving the request for the disclosure. 3. Submission of the response of the defendant, manufacturer not known, supplier of the product to be purchased by the defendant together with the request written statement and the process claim and any patent the scope of the response not used to product such product. Failure to perform any act desired by the preceding section, evidence of the absence of good faith unless they are mitigating circumstances. Mitigating circumstances include the cases due to the nature of the product, number of the source of the product, likes, commercial circumstances of the request of the disclosure is not necessary practical to avoid infringement. For the purposes of subsection, the request for the disclosure means written request made for the person who then engaged manufacturer product that identify all of the process patent owned or licensed to that person at the time of the request of the person reasonably believes the court be asserted infringed under Section 271G of the product were imported to offered for sale used in the United States with the unauthorized person request for the disclosure further limited to the request. 1. Which made the person regularly engaged in the United States sale of the type of the products or those manufactured for the person to whom the request is directed, include with the fact showing the person making the request plans to engage in sale of such products in the United States. 2. Which is made with such a person before the person first importation, offer, sale of the sale of the unit's product produced for the infringing process before the person have the notice of the infringement with respect to the product. 3. which includes representation by the person making the request for such person and prompt submit with an in-person identified person with a request of the manufacturer or manufacturer is not known. The supplier of the product to be purchased if the person making the request will request the manufacturer supplier with a written statement with a number of the process claimed in this patent used to manufacture the product. In this case, the request of the disclosure received by that person whom the patent is licensed to patent shall either identify with the patent promptly notify the licensor of the request of the disclosure. C. Person that is marked with a manner with a prescribed subsection A with the number of the process patent on all products made with the patent process which have the offered sale and sold. Person in the United States imported by the person of the United States before the request disclosure received is not required to respond with a request for the disclosure. For purpose, the preceding sentence term of all the products does not include the products made before the effective date of the Process Patent Amendment Act 1988. 5A. For the purpose of selection, notice of the infringement means actual knowledge of the receipt of the person written notification, combination thereof of the information sufficient to persuade a reasonable person likely that a product was made and processed patented in the United States. Written notification of the patent holder charging the person with infringement shall specify that the patent process alleged to have used in reasonably good faith belief that such person was used. A patent holder shall include with the notification information reasonable and necessary to explain how fairly patent holder's belief, except if the patent holder is not required to disclosure of trade secret information. See, a person who received the written notification described in subparagraph B for the written response to the request of disclosure described in paragraph 4 of the deemed that have noticed infringement respect to any of the person referred. Such as a written notification response unless the person is absent mitigating circumstances. 1. Prompt transmission written notification response manufacturer is not known when the supplier of the product purchased to be purchased by the person. 2. Receive the written statement of the manufacturer supplier with a face that's worthwhile with a ground factual basis of belief that identified patents are not infringed for the purpose of subsection person with the taken product passed as patent in the United States quantity of the abnormally large relating to the volume of the business such person effective inventory level. Shall be repeatable, presumed the actual knowledge that the product was made by such patented process. 6. Person receiving the response of the request disclosure subsection shall pay for the person to whom the request was made reasonable fee to cover the actual costs incurred with complying with the request with the not exceed the cost commercially available. The automated patent search of the material matter involved is not less than more than $500. With the respect for the medical practitioner performance of medical activity constitute the infringement section 271A or B, the provisions section 281, 283, 284, 285 shall not apply but against medical practitioner against related healthcare entity with respect to the medical activity. For the purpose of subsection, the term medical activity means with the performance medical surgical procedure of the body should not include 1. The use of the patent and machine manufacture composition matter of the violation of such patent. 2. The practice patent use of the composition matter violation of such patent. 3. The practice process violation of biotechnology patent. B. Term medical practitioner means with a natural person licensed in the state to provide medical activity described in section C1, acting on the direction such person performs medical activity. See with the term related healthcare administration meaning with the entity with the medical practice for the professional affiliation which the medical practitioner perform medical activity included not limited to the nursing home, hospital, of the university, medical school, health, maintenance, organization, group, medical practice, and medical clinic. Term professional affiliation shall mean staff privileges, medical staff membership and employment, the contractor relation, partnership, ownership, and interest for the academic appointment, other affiliation of the medical practitioner provides medical activity on the behalf of the association before healthcare entity. The term body shall mean with a human body, organ, and cadaver, non-human animal used medical research or instruction, regulating treatment of the humans. Term patented use of composition matter does not include the claim of the method of performing a medical surgical procedure for the use of the recite use of the composition matter where use of the composition matter does not directly contribute to the achievement of objective claimed method. Term state shall mean state of territory, United States District of Columbia, Commonwealth of Puerto Rico. Subsection does not apply the activity to any person, employee, agent of supervisor, such person, regardless of such person tax exemption organization under section 501C, the Terminal Revenue Code who is engaged in commercial development, manufacture, sale, importation, or distribution, machine manufacture, composition, matter provision, pharmacy, clinical laboratory, service to other clinical laboratory, service to provide physician office, which of such activities. Directly related commercial development, manufacture, sale, importation, distribution, machine, manufacture, composition, matter provision, pharmacy, clinical laboratory, services other than clinical laboratory services provided physician office. Be related under Federal Food, Drug, and Commercial Act of Privacy, Healthcare Service Act, or Clinical Laboratories Improvement Act. Subsection does not apply to any patent issued based on an application which is effective filing date before September 30th, 1996. Title 35 U.S. Standard Code 288, acting on infringement of a patent containing invalid claim. Whenever the claim of the patent is invalid, action may be to maintain an infringement claim of the patent which may be valid. Patent which shall recover no costs. The patenter shall recover no costs unless the disclaimer invalid claim has entered in the Patent and Trademark Office before commencement of suit. Title 35 U.S. Standard Code 288 Pre-Americanism Inventor Act, action infringement of patent containing invalid claim with a deceptive intention claim of the patent invalid action maintained with infringement of the claim of the patent which made valid. Patent should recover no cost. Disclaimer: the invalid claim has been entered with the Patent and Trademark Office before commencement of suit. Title 35 U.S. Standard Code 289. Additional remedy of infringement design when during the term of the patent design without license for the owner. One applied with the patent design colorable imitation thereof any article of the manufacturer for the purpose of the sale to sell with exposed for the sale of the article of manufacturer which such design color limit imitation as applied shall be liable to the owner except for the total profit not less than $250 recovered the United States District Court of Jurisdiction of the parties. Nothing in this section prevent less than impeach any other remedy owner of the infringed patent as under the provision of the title shall not twice recover the profit made in infringement. Title 35 U.S. Standard Code 290 notice of patent suit for the clerk of the courts of the United States within 1 month after filing an action of the title shall give the notice thereafter the written director set forth as far as known with the name and address of the party's name of the inventor, designated number of patent upon the action had brought the author of their patent and subsequent include the action, give the like and the notice thereof with 1 month after the decision rendered by the judgment issued clerk of the court. Give their notice of their director. The director shall, on receipt of such notice, enter the same file with such same patent. Title 35 U.S. Standard Code 291 derived patents. In general, the owner of the patent may relieve the civil action against the owner of another patent with claim such invention with either earlier effective filing date if the invention claim such other patent was derived from inventor's invention claim with a patent owned by a person seeking relief under section. Filing limitation. Any action on the section may be filed before the end of the 1 year period over the date of issuance first year patent claim containing a claim to allegedly derived invention naming with an individual alleged to derive such invention inventors or joint inventors. First inventor to file with the provision of American Invention Act apply if such applications of the patent contained at any time a claim of the invention effective filing date defined in Title 35 U.S. Standard Code 100.1 that occurs before March 16, 2013 or specifically referenced under Title 35 U.S. Standard Code 120, 121, or 365C to any patent application that contains time in such claim. Title 35 U.S. Standard Code 291 Pre-American Inventors Act interfering patents. The owner of the interfering patent may relieve it against the owner of another civil action. Court may judge question validity any interfering patents in whole or in part. The provision second paragraph section 146 shall apply for the actions brought under the section. A. The claim of the invention have an effective filing date defined in Title 35 U.S. Standard Code 101 that occurs March 16, 2013, or B. Specifically referenced Title 35 U.S. Standard Code 120, 121, or 365C. Any patent application that contains any type of such claim. Title 35 U.S. Standard Code 292 false marking. With or without consent of the patent or marks on the affix of the advertising connection with anything made, used, offered, sale, sold with such person in the United States, imported person in the United States with the name of the limitation of the name of the patent or patent number to the words patent, patenter, or like the intention, counterfeiting, and initiating, imitating mark of the patent, deceiving the public and inducing them to believe that this was made, offered, sold with the imported United States with the consent of the patent, whosoever marks upon, affixes the, or uses the advertising connection unpatented article in the word patent, any word numbering, importing same patent for the purpose of deceiving the public who the works, whoever marks upon affixes use the advertised connection articles work with the patent applied with the patent pending any word importing any application patent has made with the any. When no application for the patent has been made, it is not pending. If for purpose of deceiving the public, shall be fined no more than $500 for every offense. Only with the United States may receive the penalty authorized by the subsection person who suffered the competitive injury as the result of violation. Section civil action, district court, United States for the recovery of the damage, would compensate for the injury of the marking product of the manner described in the subsection A for the matter relating to the patent that has covered the product, but is not expired and not violating the section. Title 35 U.S. Standard Code 293, non-resident patent or service notice. For every patenter not residing in the United States may file the patent trademark off with a written designation on using the name and address of the person residing in the United States or whom the serve of the product. Notice of the proceedings effective on the patent right thereunder, but if the person designated cannot be found in the address given in the last designation, if the person has no designation in the United States District of the Eastern District of Virginia shall have jurisdiction summoned and served publication otherwise court directs. Court shall have the same jurisdiction take action respecting patent rights and thereunder the would have the patent or would personally within jurisdiction of the court. Title 35 U.S. Code 294 voluntary attributed to contract involving the right and right under the patent with the containment of the provision requiring arbitration with a dispute with the relating patent validity or infringement arising under the contract for the absence of such a patent provision of the parties to the existing patent validity infringement dispute with a may agree with the written still dispute with the arbitration. Any such provision agreements shall be valid, but they are revocable and enforceable except if any of the grounds exist in the law with the equity with the revocation of the contract. Arbitration such disputes, such arbitrators confirm the award shall be governed with a Title IX exemption with a touch level inconsistent with the section. Such arbitration proceeding with defense provided with under Section 282 should be considered for the arbitrator raising party to the proceeding. C. Award arbitrator shall final and binding between parties. Arbitration shall have no force effective with the other person from the parties for the arbitration made with the agree with the event with the patent subject matter of the award subsequent determined invalid with the unenforceable of the judgment. Enforceable judgment rendered with the court competent jurisdiction for the no appeal for the king has been taken. Such award may be modified by the court. Competent jurisdiction under the U application part of the arbitration. A for the modification govern the rights obligation between the such part of the day of some modification. When the award may be the arbitrator of the patent with the assigned license with the given the notice written with the direct for the separate notice prepared to each for the patent involved with such proceedings. Such notice set forth the name of the address of the parties, the name of the inventor, the name of the patent owner. Shall designate the number of the patent shall contain the copy of the award. If the award notified with the court party requesting such modification shall give the notification modification of the director shall Pharmacy either notice the enter for the same of the record prosecution such notice, and if the required notice filed with the director, any part of the proceeding may provide such notice director. The award shall be unenforceable with the notice required subsection D of the is received by the director. Title 35 U.S. Code 295 Presumption product may be patented actions aligning the infringement process patent based on and portion sale with the authored sale with the the product made with the process patent in the United States for the court finds when the substantial likelihood exists for the product was made with the patent process and the plaintiff has made with a reasonable effort to determine the process actually used the production product was unable to determine the product shall be presumed to have been made also been so made and burden establishing the product was not made with the process shall be on the party asserting that it was not made. Title 35 U.S. Standard Code 296 Liability States Instrumentality of State Officials Infringement Patents in general that any state instrumentality of the state of the officer employed with the state of the instrumentality of the state acting on the official capacity shall not be immune under the 11th Amendment of the Constitution of the United States under the aid of the doctrine of sovereign immunity from the federal court with any person including with the government, non-governmental entity of the infringement of the patent under Section 271 for any other violation of this title be remedy within C with the description subsection A violation described in the subsection remedies included remedies both laws and equity available to violation same extent with the remedies available such violation suit, and I can provide the entry for such remedies include the damage and interest cost, treble damage under the Section 284 attorney fees, Section 285 additional remedy infringement design patent 289. Alright, Title 35 U.S. Standard Code 297, proper deceptive invention promotion. Invention promoter shall have the duty to disclose the following information customer written prior entry for the contract invention promotion services. Total number of the inventions evaluated by the invention prompted for the commercial potential in the past 5 years, as well as the number of those inventions received the positive evaluation for the number of those inventions received the negative evaluations. 2 of the total number of customers received the contract with the inviter and invention for the promoter with the past 5 years, not including for the customer purchase trade show, services reach for the advertising and marketing services from the invention promoter, who default with the payment of the invention promoter. 3. Total number of the customer known with the invention prompter for the receipt of the net official financial profit of the direct result of the invention prompt services provided with the stuff of the invention prompter. Total number of the customer known with the invention promoter with the receipt of the license agreement for the invention for the direct result of the invention promotion services providing such an invention promoter with the name and address for all the previous invention for the promotion companies, which invention promoters, if the officer of the collective of the individual have been affiliated with the payers 10 years civil action. Any customer with the contract with the invention promoter was found by the court having an injury with a material false or fraudulent statement of representation, any omission of the other material fact by invention promoter, agent, employee with the director, officer of the partner, individual contractor, such invention promoter, or by fault affiliated invention promoter with the disclose such information as required under subsection A, but they may recover civil action against the invention promoter, officer of the director, partner, such invention promoter, in addition to the reasonable cost of attorney fees. Here, the amount of actual damage has been incurred by the customer and the element of the customer any time before the final judgment renders statutory damages and some not more than $5,000. Court just considers just. Notwithstanding paragraph 1, in the case of the customer sustained with the burden of proof, the court finds that the invention promoter intentionally misrepresented the omitted with the material fact of the customer who he fully failed to disclose such information required on subsection A with the purpose of deceiving the customer. The court may increase the damage with not more than 3 times the amount awarded, taking account past complaints made against the invention promoter result of the regulatory sanction of the other correctively action-based correctors comply with the commission patents under subsection D. Or definition for the purpose of the contract, the invention promotions for the contract or invention promoter undertakes the invention of the promotion service to the customer, individual entity for the contract with the invention promoter for the invention promotion services. The term invention promoter means any person with firm, partnership, corporation, or other entity who offers the performs invention promotion services for and on behalf of the customer who holds itself out for advertising mass media with providing such services but does not include A, the department, agency of the federal government and state of the local government, any non-profit, charitable, scientific, educational organization qualified to applicable state law with the described in Section 170B1A of the Internal Revenue Code in 1986. C, any person involved with the evaluation determining commercial potential, offering a license to sell a utility patent, previously filed non-provisional utility patent. D, any party participating in transaction involving sale or stock assets of the business, or E, any party directly engaged in the business, the retail sales product, the distribution of the product, and 4, term invention project promotion services mean the procurement attempts the procurement with a customer, firm, corporation, other entity to develop the market products, services that would include the invention of the customer. Records of the complaint, release of the complaint, Commissioner Paynes shall make complaints received with a patent trademark office involving the invention promoter to the public available to give the response of the invention promoter's commercial patent shall notify the invention promoter with the complaint with a provide reasonable opportunity to reply with the making such public complaint publicly available. The request of the complaints to the Commissioner Patent with the request of complaints relating to the invention promotion services for federal state agencies, including such complaints of the records maintained under paragraph 1 together the response of the invention promoters. Title 35 U.S. Standard Code 298, advice of the counsel failure infringement of obtaining the advance advice of the counsel with respect to the alleged infringed patent failure of the infringer present. Such advice of the court or jury may be used to provide accused infringer willfully infringe for the patent infringer intended to do with infringement of the patent. Title 35 U.S. State Code 299, Joiner Parties. Joiner accused infringers for the respective civil action arising from the act of Congress relating with a patent with the other than the action travel with the act of infringement under Section 271E that has been pled in parties with the accused infringer to be joined with the one action, the defendant with a counterclaim, the defendant with the half of the action consolidated with the trail over the others. Trial of the only if any right with the relief the served against the party with the trouble of the alternative with the respect arising on out of the same exact transaction occurrence with the areas of the transaction occurrence related with the making, using, importing into the United States for the offering, sale, selling the same accused product process, question of the false comment, the defendant with the counterclaim, the defendants will arise the action. Allegation insufficient for joinder. Purpose of the subsection accused infringers may not be joined action. One action defendant with the counterclaim, defendants over the head of the action consolidated trial based solely on allegations that each have infringed on the patents or patents in suit. Waiver. Any part in that is accused for may waive the limitations set forth in section with respect to the party. Chapter 30, Prior Art, Citations to Office Ex Parte Reexamination Patents.